From a separation of powers argument and a due process argument, we would accept that at first blush, that would appear to be contrary to separation of powers. It is the legislature that is imposing that sentence. The judge has no discretion in terms of pronouncing the sentence of life imprisonment. The jurisprudence coming from the United Kingdom elsewhere, as well as the European Court of Human Rights, suggests that one gets around that by accepting that the ability of the judge or the duty of the judge to individualize that sentence by saying, I am setting a minimum period that you must serve before becoming eligible for parole, that period, the minimum period, for all intents and purposes, constitutes a judicial determination of sentence, and therefore, even though the legislature has said life sentence, life does not mean life, and that in fact, what happened, it is a judiciary that pronounces and determines the period of sentence. After the minimum period has expired, you then come to the question of parole. And the jurisprudence, as we understand it, says that parole does not have to be determined by the judiciary, properly so called, but it must be determined by an independent body after due process given to offenders. If that process is involved, if an independent and fair parole board is in place, then the offender who, although under a life sentence, has an opportunity to say, I am eligible for parole, with the sole issue being considered whether or not he or she pose a risk to the society or to himself if released. Then the person comes out. The person is monitored. His liberty is not full, but he is free from confinement in prison. Taken together, as a whole, the jurisprudence suggests that, one, notwithstanding the formal pronouncement of life imprisonment, the sentencing, punishment, retribution, and deterrence actually is imposed by the judiciary, which would then satisfy the separation of powers requirement.